Welcome to Do It for the Case Law for Tuesday, July 14th, 2026. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Today's docket features 80 cases across 10 circuits. We begin with immigration, environmental, and administrative law from Raj Patel, followed by business, labor, intellectual property, and consumer protection coverage from Maria Santos. Michael Reeves turns to habeas corpus, prisoner litigation, and constitutional challenges, while Aisha Johnson reports on civil rights including employment discrimination and Section 1983 claims. James Taylor closes the docket with drug trafficking, firearms, robbery, and violent crime appeals. Please subscribe for daily federal appellate updates. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Let's turn to James covering criminal justice.
Thanks, David. Today we have 19 cases from the 10th, 11th, 4th, 5th, and 8th circuits covering drug trafficking, firearms, fraud, and violent crimes. The disposition roll-up is 9 affirmances, 7 dismissals, 1 remand, and 2 other outcomes where the court addressed specific procedural or legal issues individually. Starting with the 5th Circuit, we see a cluster of summary calendar dispositions. 7 cases were dismissed after appointed counsel filed Anders briefs asserting no non-frivolous issues existed for appellate review. Hall, Mora Hernandez, Perkins, McNeil, Rubel, Taylor, and Mendoza-Garcia. The court in McNeil declined to consider an ineffective assistance claim on direct appeal without prejudice to collateral review due to an underdeveloped record. One case involving Larry Simmons was remanded to the district court to correct a clerical error in the judgment regarding the date the offense ended. Moving to the 4th Circuit, we have 2 affirmances. In the case of Kirsten Ball, the court rejected arguments that jury instructions failed to account for the Supreme Court's decision in Ruan, clarifying that while subjective knowledge is required, the scope of unauthorized prescribing remains an objective standard based on professional practice. In Stephen Snyder's case, the court affirmed convictions for attempted extortion and Travel Act violations, upholding the trial court's decision to allow him to proceed pro se, despite cognitive decline and rejecting arguments regarding jury instructions and witness testimony limitations. Over in the 11th Circuit, the court affirmed the convictions and sentences of Ricard, Baird, Nguyen, and Hong for kidnapping and stalking. The court found the defendant's evidence insufficient to support a duress defense, applying the 3-element test requiring an immediate threat of death or serious bodily injury, a well-grounded fear, and no reasonable opportunity to escape. In the 10th Circuit, we have 4 substantive dispositions. The court affirmed Mario Terrell McBee's conviction for felon in possession, rejecting evidentiary objections regarding an ATF agent's testimony as not meeting the plain error standard. Peter Pham's appeal was dismissed after the court enforced his appeal waiver, leaving his sentence of 120 months intact. In United States v. Arnett, the court affirmed a 77-month prison sentence for felon in possession, but noted that the district court committed error by using a factual approach rather than the categorical approach to determine prior drug convictions, though the error did not affect substantial rights under plain error review. Finally, in the 8th Circuit, Antonio Copeland's 292-month sentence for methamphetamine distribution was affirmed. The court held that while the Supreme Court prohibits presuming a guidelines range is reasonable, Copeland failed to show an obvious error occurred based on the specific transcript remarks cited. Back to you, David.
Thanks, James. Now for civil rights and employment law, Aisha has the rundown.
Thanks, David. We have 13 cases from 4 circuits today, 2 split outcomes, 1 reversal and remand on liability, 3 reversals or reversals with remands, 1 dismissal, and 6 affirmances. Let's start in the 5th Circuit, where we see a split decision in Brenda Brenya versus Columbia Hospital Corporation of Bay Area. The court affirmed summary judgment for the employer on race discrimination, national origin claims under Title VII, Section 1981, race claims, disability claims under the ADA, retaliation, interference, and failure to accommodate theories. However, the court reversed summary judgment on hostile work environment claims under Title VII and Section 1981, finding that the first EEOC charge was the only timely basis for those allegations, while a second charge was untimely. Moving to the same circuit, 3 cases involving state judges were affirmed with prejudice. The court held that neither states nor officials in official capacities qualify as persons under Section 1983 of Title 42, and absolute judicial immunity barred individual capacity claims regarding courtroom management. Also in the 5th Circuit, Lance Parsons versus Matthew Valdez was reversed on qualified immunity grounds. Deputy Valdez was found to have had arguable probable cause for the arrest, negating false arrest liability under Section 1983 of Title 42. Now over in the 9th Circuit, we have a significant reversal and remand for Comet Technologies USA versus XP Power regarding trade secrets D, E, and L under the Defend Trade Secrets Act. The court held that instructing the jury that the defendant bore the burden of proving information was readily ascertainable was reversible error because the plaintiff must prove this as an essential element. Additionally, the Ninth Circuit reversed a mid-trial dismissal in the Equal Employment Opportunity Commission versus Covia's Services case, finding abuse of discretion in excluding an email from an Aerotech recruiter under Federal Rule of Evidence 807. In a related Ninth Circuit decision, PH versus Compton Unified School District was affirmed on both the merits and attorney's fees. The court held that the school district denied a student a free appropriate public education under the Individuals with Disabilities Education Act and had jurisdiction over the fee appeal because the district court entered final judgment on fees while the merits appeal was pending. Finally, in the Tenth Circuit, Van versus Fuel was affirmed regarding excessive force and medical needs claims for a pretrial detainee. The plaintiff failed to exhaust administrative remedies on retaliation claims and qualified immunity applied. In the Fourth Circuit, Roy Sylvester Hunt versus P. McCabe was dismissed for lack of jurisdiction because the notice of appeal was filed after the 30-day deadline under Federal Rule of Appellate Procedure 4A1A.
Up to you, David.
Thanks, Aisha. Let's turn to Michael for the latest on Supreme Court and constitutional law.
Thanks, David. I have 9 cases from the 10th, 4th, 5th, 8th, and 9th Circuits covering habeas corpus, PLRA disputes, and supervised release conditions. The disposition mix includes 1 vacatur remand, 1 remand, 3 affirmances, 3 denials, and 2 dismissals. We start with movement cases before rolling through the routine outcomes. In the 5th Circuit, the court granted Terrence Gore's motion to proceed in forma pauperis on appeal, finding the district court erred in denying his request because paying the fee would deprive him of life's necessities. Consequently, the court vacated the dismissal and remanded for further proceedings consistent with this opinion. Also in the 5th Circuit, the 8th Circuit remanded Malcolm Redmond's supervised release sentence to reconsider a community service condition after finding the district court did not violate precedent by considering the nature of the offense, though it did err on the specific condition imposed. Moving to the 10th Circuit, the court denied Christopher Barnett's motion to proceed in forma pauperis under the Prison Litigation Reform Act because he failed to show an imminent danger of serious physical injury linked to his claims despite having 3 prior dismissals. The 10th Circuit also denied a certificate of appealability for Isaiah Gilbert's habeas petition, ruling that reasonable jurists could not debate the district court's determination that his federal petition was untimely under Section 2244 of Title 28. In the 4th Circuit, the court dismissed Hardik Patel's appeal and denied a certificate of appealability because he failed to make a substantial showing of a constitutional denial regarding procedural default. The 5th Circuit affirmed Jason Keller's habeas denial after rejecting his argument that his ICU confession was inadmissible under the fruit of the poisonous tree doctrine. In the 9th Circuit, the court affirmed the denial of Teresa Torresellas' habeas petition, holding her claim was time-barred or harmless error under AEDPA standards. The 5th Circuit also dismissed Antwine Jenkins' appeal as frivolous for failing to exhaust administrative remedies and rehashing arguments without new evidence. Finally, the 5th Circuit affirmed the denial of Marvin Reyes' motion to withdraw his guilty plea due to insufficient record for ineffective assistance claims. Back to you, David.
Thanks, Michael. Let's turn to Maria covering business and civil law.
Thanks, David. 17 cases in this block. 13 were affirmed, 1 was dismissed, 4 were reversed, vacated or remanded, and 1 had a split outcome.
Moving to the Fourth Circuit, the court vacated and remanded an attempt to confirm a foreign arbitration award because the petition was filed more than 3 years after the award, violating the mandatory statute of limitations under the Federal Arbitration Act. The court also reversed in part a dismissal regarding a federal employee's assault on a plaintiff, finding that government liability for negligence resulting from an assault is permissible where the duty breached is independent of the tortfeasor. In immigration matters, the court granted a petition and remanded because the refusal to accept a timely motion to reopen under the Violence Against Women Act violated due process rights when electronic filing was thwarted. Over in the Fifth Circuit, the court vacated an ERISA judgment regarding retirement benefits because the plaintiffs failed to demonstrate a concrete injury in fact sufficient for standing under Article 3. The court also reversed a municipal liability verdict while affirming qualified immunity for an officer, sending the case back for a new trial on the city's responsibility after finding the jury's answers irreconcilable. In the Seventh Circuit, 3 appeals challenging the Small Business Administration's corporate group rule limiting Paycheck Protection Program loans to $20 million for affiliated entities were affirmed, with the court upholding the agency's interpretation that a business concern includes all entities under common control. Moving to the Ninth Circuit, the court affirmed an antitrust verdict where the plaintiff failed to prove its market definition and waived challenges by filing a broader complaint. Another affirmance dismissed a class action alleging deceptive marketing of Medicare Advantage plans because state law claims are expressly preempted by federal standards. The court vacated and remanded regarding mandatory attorney's fees under Washington law, ruling that the amount pleaded can be below $10,000 if notice was provided before trial. In an immigration case, the court found substantial evidence did not support the agency's conclusion on the nexus between religion and past persecution, even though the inability to pay extortion was not a valid particular social group. The Eighth Circuit resolved one lower priority case which was affirmed. Back to you, David.
Thanks, Maria. Now for immigration and government news, let's turn to Raj.
Thanks, David. We have 22 substantive cases today. The disposition roll-up shows 1 reversal remand, 2 remands, 3 dismissals, 15 denials, and 1 affirmation. First up in the First Circuit, the court reversed a district court's order in Crystal Chirono versus General Electric Company. The appellate court held that GE satisfied the federal officer removal statute by showing it acted under federal authority during World War II to manufacture specialized components for military needs. Moving to the 10th Circuit, the court remanded Mukantagara versus Mullen following a petition for panel rehearing to address jurisdictional questions after the Supreme Court's recent decision in Mullen versus Doe. In the 11th Circuit, the court dismissed Beresford Landers Jr. versus the Board of Immigration Appeals, ruling it lacks jurisdiction over administrative disbarment orders which must be brought in district court instead. The 4th Circuit denied Clinchfield Coal Company versus Director, Office of Workers' Compensation Programs, finding substantial evidence supported an administrative law judge's award of black lung benefits under Section 901-944. Over in the 5th Circuit, the court denied Precision Refractory Services versus Oshrik regarding scaffolding safety violations and affirmed 3 immigration cases denying asylum and withholding of removal for Angel Jefferson Reyes Medina, Virginia Gizel Alberto Cardoza, and Zira Yamileth Borjas Gonzalez due to lack of protected ground nexus or failure to internally relocate. The 5th Circuit also remanded Vernon Smith versus School Board of Concordia Parish, ruling that a joint stipulation of dismissal terminated the case immediately under Federal Rule of Civil Procedure 41, securing District Court of Jurisdiction for subsequent orders. In the 6th Circuit, the court denied Gabriel Mejia Perez and Ricardo Rodriguez Sanchez versus Todd Blanche, finding substantial evidence supported the denial of cancellation of removal due to insufficient proof of exceptional hardship to their citizen children. The 7th Circuit affirmed Seth Steidinger versus Blackstone Medical Services regarding a claim that text messages violate the Telephone Consumer Protection Act, ruling the statute only covers voice calls, and affirmed Derek McCoy versus Markwayne Mullen on an age discrimination claim where the plaintiff failed to provide sufficient comparator evidence. The 8th Circuit denied Zira Yamileth Borjas Gonzalez versus Todd Blanche for failure to challenge the internal relocation finding in Honduras. Finally, the 9th Circuit dismissed Sinorbe versus Blanche due to adverse credibility findings and denied 5 additional immigration petitions. Dominguez Parra versus Blanche, Hernandez versus Blanche, Moreno Arias versus Blanche, Popov versus Blanche, and Vargas de Campos versus Blanche, all upheld on grounds of substantial evidence regarding lack of protected ground nexus or failure to meet statutory hardship requirements. In the D.C. Circuit, the court affirmed Alignment Healthcare versus the Department of Health and Human Services upholding Medicare star rating calculations, but vacated and remanded State of New York versus Donald Trump, holding that the district court lacked jurisdiction over claims challenging Postal Service operational changes which must go through the Postal Regulatory Commission first. Back to you, David.
This wraps up Do It for the Case Law for Tuesday, July 14th, 2026. A huge thank you to James Taylor for 19 cases, Aisha Johnson for 13 cases, Michael Reeves for 9 cases, Maria Santos for 17 cases, and Raj Patel for 22 cases. Today's docket saw 1 reversal or remand stand out as the most significant outcome, alongside 35 affirmances and 18 other dispositions, with a number of appeals dismissed on procedural grounds. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction. Please subscribe and follow us for tomorrow's briefing.